We're live.
Thank you. Michelle Childs is with us to do a walkthrough of H40. I want to make clear that just by bringing the bill up and doing a walkthrough and maybe taking testimony next week, there's no guarantee that the bill, that we have time to complete thoughtful work on a bill in the time that we have left. We're basically going to shut the committee down effective next Thursday. We will try to meet for 45 minutes to an hour each morning, but a lot of that time will be spent looking at House changes to Senate bills and Senate changes to House bills and conference committees and other items. So I don't want to get people's hopes up that this bill will make it this year, but it certainly is something that we would take up next year if it doesn't make it. So with that, I'd ask Michelle to walk us through the bill.
Thank you.
As it passed the House.
Correct. So for the record, Michelle Childs, Office of Legislative Counsel, and we're going to take up H40 as it passed the House. So it's an act relating to non-consensual removal of or tampering with a condom. Essentially, it is creating a civil right of action to for a plaintiff to be able to sue someone for engaging in that conduct without consent. So I'm going to go to the bottom. So just up above, you have the definitions that are used in the section. So you see a definition of sexual act, which we have this. So we're working in Title 13 in Chapter 72, which is the sexual assault chapter. And so the new section starts at the bottom of page 1. So Section 2, non-consensual removal or tampering with a condom. And you'll see subsection A, the element. So no person shall engage in a sexual act with another person.
Before you go there, Michelle, how can a civil right be in Title 13?
So there's a kind of a question about whether or not...
I thought Title 13 was only for criminal.
There are civil penalties within Title 13. You can put it in Title 12 as well. We debated this a bit. However, there's no great place to put it in 12. 12 is a little bit of a mess, and looking at it, it seemed as though it would be buried there. And so it seemed to me as though the most appropriate place would be to put it where somebody would be looking for it. This bill, as introduced, also had a minor misdemeanor offense that was struck by House Judiciary, so they just left it with the civil right. But there's no problem with having it in 13. If you want to move it to 12, you can. But we looked at that, and there really wasn't any place that I think you would easily be able to track it down. You'd have to know what you were looking for and where it was.
All right, but I flagged that as a problem. So.
Okay, so the terms that it uses also are terms that are used in the criminal context in terms of sexual act and consent. And so those are terms that are defined within Chapter 72. So no person shall engage in a sexual act with another person when consent to the sexual act is made with the explicit understanding that a condom would be used, and then and the person intentionally and without consent to remove or tamper with the condom prior to or during the sexual act removes it or renders it ineffective for its common purpose. So you'll see in subsection B that a person harmed by a violation of subsection A can bring an action in civil division for compensatory, punitive damages and reasonable costs and attorney's fees. So it has the usual statute of limitations. I didn't grab my file on the way in, but I'll take a look at that and see what it is for the statute of limitations. And that's it. So you'll get
3
some
years
background.
or 6 years? You don't know if it's 3 or 6.
I think it's 6, but I'll have to double check.
Okay.
So the witnesses can explain to you the background, but this is currently a law in California. And there are a few, I think, European countries that consider this activity to fall within the definition of sexual assault. So it can be prosecuted as a sexual assault. But California is the only state that I know of right now that currently has this law.
Why do we need, I mean, isn't there some other law that covers this?
I think I would leave that to the witnesses as to why this law is needed in terms of whether or not, if you look at our consent laws, it talks about consent to the sexual act. And I think that you would have to maybe hear from the state's attorneys or others about whether or not if someone has consented to the sexual act, but not consented to the sexual act without a condom, is that then void the consent? And then do you have to make all of those arguments, that kind of stuff? So that's in the criminal context. This is providing for the opportunity for someone to sue them civilly for that type of conduct. Perhaps they don't want to go through the criminal process and would prefer to approach it in the civil context.
How would one prove that it was? How would one prove either one way or the other? Assuming there's only 2 people involved.
I think that is just the way they do with a lot of sexual offenses currently. You just have to present evidence, and then it's going to be up to the court to determine whether or not you meet the standard. Okay. I would imagine these are going to be tough cases to bring, just as sexual assault cases are tough to bring.
Thank you.
I got a question.
Yes, please.
Yeah. I'm not sure I know where to begin on this one. So Senator Sears brought up the question of the burden of proof, and due to the fact that this is in the civil division, so I can assume that law enforcement will not be called to these complaints.
Correct. I mean, there may be, depending about the consent issue and whether or not there's a violation of the sexual assault statute, but that's a separate matter. This is just dealing with this one particular thing, which is that there's been a consent to sexual act with the understanding that a condom would be used, and then one of the party removes the condom or renders it inoperable. So then is basically voiding the consent in that situation.
And what is the level of proof?
In civil court is preponderance.
Preponderance, so it's not clear and convincing, it's the level.
Right.
Preponderance of the evidence. Mm-hmm. Well, I guess we covered with another person to suggest it's everyone involved in this sexual act, correct?
I'm sorry?
Rather than he, she, with another person, you're covering all of the context of the this act.
Yeah.
Okay. That'll be. I'll wait for the witness. It'll be interesting. So I'm all set. Thank you.
Sure.
You could take the screen share down. Interesting. Thank you, Michelle. Are there any other questions about this bill?
No, the bill seems pretty straightforward, but I look forward to hearing from witnesses.
Yep. I don't, going back to my agenda, and I think, Michelle, you walked through that, which I didn't realize it was only 2 pages, and you didn't really need a half an hour. but thank you for
Not.
filling in at the last minute.
Sure.
I do have one quick question, Senator Sears.
Sure.
I was just curious, California is the only state that has enacted this law here. Do we have any case laws in California or
No.
conviction rates or anything there? How long has it been in effect in California?
Maybe 2 years.
So we have no idea how many cases have been before civil court. It's a very large state, large population. You think that they would.
Right. I mean, some of the witnesses might know. I don't know. I know the network testified on it.
I know Jessica's in the background and maybe she can get us information on the number of cases in California.
Does look like Senator Verhofstadt has a question for Michelle.
Yeah, Michelle, you may not know
okay.
the answer to this, and this may have to wait for the witnesses, but are you aware of any other states that are introducing legislation like this? I see heads nodding.
There are a number,
Okay.
and I don't know what it is lately, but I'm guessing somebody behind me probably.
I see heads nodding, so.
Yes, it is. It has been introduced in a number of states. Yep.
Thank you.
With the time we have left, and we'll have a rather lengthy break between now and the time the Senate convenes, but I wanted to update you on a couple of things, the committee. It looks like the House will be voting out S6, which was the interrogation bill, today. They hope to. They hoped about vote out S4 on Tuesday. That's the community violence bill. And they are working on S89, the forensic bill. But as happens in the House, they're waiting to hear from institutions and corrections and health and welfare and human services, or not health and welfare, but health committee and then the human services committee. So they have 4 committees looking at 89 and we'll see what happens. S33, which was the miscellaneous bill, we will begin taking a look at that, but it may not be voted out till the end of next week or towards the middle of next week. And they probably are not going to get to S27, which was the bail bill.
Senator Sears, I did talk to Representative Lalonde last night about S27 on the possibility of the Sentencing Commission taking up the study over the summer in sort of preparation of doing the bill next year. I'd love to talk with you more about that. Well,
happy to. We could. I'm glad you had that conversation. So, at any rate, that's my latest update on what's going on with our bills. I believe Health and Welfare is looking at S36 this morning, and but we put in the amendment or the concur with further proposal amendment on tumultuous, and from there we're ready to go. Is there anything else anybody wants to bring up before the end of the week?
And we have S33 on Friday.
Yeah, I'm hopeful that they will get it out.
Sorry, it's on Thursday.
Yeah, hopeful they'll get that out by next Wednesday or Thursday at the latest, because it's a must-pass bill and we need time to look at any changes they make.
Yes.
Anyway, hopefully I will be back in person with all of you next week. And until then, have a great weekend, even if it does pour all weekend.